So we have some major new developments in a Supreme Court case that could reshape when the federal government can be held accountable for botched law enforcement raids. This all comes out of a case where the FBI smashed into the wrong house, terrorized an innocent family, and now the government is still trying to avoid responsibility even after losing at the Supreme Court level with a unanimous decision. I also want to thank the sponsor of this video, which is Patriot Gold Group. If you've been watching the markets closely, you will know that something unusual is happening. Silver has surged to over 158% in 2025, and this move isn't over yet. It looks like the opening chapter is just happening right now. This is not the finale at all. Gold is up 60%, silver is up 150%, and that kind of move doesn't just happen by accident. Now, as a member of the Second Amendment community, this concept already makes sense to you. You believe in self-reliance, in not outsourcing your safety, and in being prepared before you're forced to actually react. Your finances deserve the same type of mindset that your self-defense also gets. That's why I work with Patriot Gold Group. They help Americans protect their savings with physical gold and silver, and these metals you can have delivered to you or held in a no-fee-for-life IRA. They specialize in rolling over IRAs and 401ks into real, tangible assets that you actually own. Now, this isn't about market panic or anything like that. It's about positioning yourself and putting yourself in the best position to defend your finances like you would defend your life. So if you're interested, check out Patriot Gold Group. You can mention Armed Scholar when you check out to get the best-in-class service from the Patriots that are focused on protecting your investments, or you can call 888-581-3830, and you can get also a free investment guide and see if you qualify for a no fee for life IRA on qualifying rollovers. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also support this channel by simply clicking the like button on this video if you appreciate it, and that just tells the algorithm that you appreciate this type of content and should share it to more people. Now, if you've been following the channel for a while, you will know that the Supreme Court recently issued a 9-0 unanimous ruling in favor of a family, and this all involves essentially a situation where back in 2017, FBI agents executed a pre-dawn raid in a suburban Atlanta area. Now, the problem with this was essentially that they raided the wrong house. The agents were supposed to go to a specific address, but instead they relied on a personal GPS device, I believe a phone, and they ended up at the completely wrong home. That was the home of Katrina Martin, where she lived with her boyfriend and their young child. And essentially the FBI raided this house, and the correct house was just simply 3 doors down. The FBI smashed in the front door, detonated flashbang grenades, pointed guns at the family, detained them, dragged her out half dressed, and only later did they realize that they actually got the wrong house. The family then responded by filing a lawsuit against the government and the FBI under the Federal Tort Claims Act, also known as the FTCA. This is the law that allows, citizens to sue the federal government when its employees commit wrongful acts. But the FBI and the government here claimed immunity using something called the discretionary function exception to the FTCA, and they argued that how the raid was planned involved discretion and policy judgments. On review, both the District Court and the 11th Circuit originally agreed with the government and the FBI, and this eventually led this case to go to the Supreme Court for review. And when this case went to the Supreme Court issued a 9-0 unanimous ruling in favor of the family. Justice Gorsuch wrote that the 11th Circuit applied the discretionary function exception far too broadly and ordered that the 11th Circuit needs to take a fresh look at whether the FBI's actions were actually protected by law. In short, the Supreme Court said that you don't automatically get immunity just because law enforcement exercised judgment. You must show that those decisions were grounded in legitimate policy choices. Now, after the Supreme Court issued that 9-0 unanimous ruling, this was sent back down to the 11th Circuit for, again, a fresh look at this case. And there have been some new developments based on the DOJ essentially doubling down on its position and telling the 11th Circuit that they should simply ignore what the Supreme Court said. The DOJ filed a new brief to the 11th Circuit arguing that the discretionary function exception still applies and that this case should still be dismissed despite what the Supreme Court said. This is now set for oral arguments to take place in front of the 11th Circuit on March 25th, so the 11th Circuit has now set dates to hear these critical arguments, and this will be argued in front of them. Now, in this case, the FBI and the government claims that the agents' mistakes flowed from discretionary decisions about surveillance, navigation, and approach tactics. They argue that no statute or rule specifically dictated how the agents had to identify the house they were going to raid, and therefore they claim the discretionary function exception still blocks this lawsuit from going forward. So essentially, in other words, the DOJ is trying to preserve the immunity by repackaging some of the same arguments that they already made to the Supreme Court, in which the Supreme Court actually rejected. Now, the family here has responded, and they fired back with a very powerful response brief. They argue that the federal government cannot hide behind the discretionary function exception for these type of basic operational failures by the FBI. Their core argument is very simple. They state that executing a warrant at the correct address is not a policy decision. It is a ministerial duty, something where there is no discretion at all. Federal agents do not have discretion to raid the wrong home or to simply ignore the correct address on a warrant. They argue that the discretionary function exception was meant to protect actual policy judgments, not reckless mistakes like ignoring the address on a warrant and trusting a personal GPS device. The brief argues that raiding the wrong home, traumatizing an innocent family, and pointing guns at the family is not grounded in any legitimate federal policy. And they claim that once this shield is removed, once the FTCA discretionary function exception goes away, like the Supreme Court potentially hinted at, simply then you just apply the state standard, and that is simply if a private person would be liable under the state law for this type of conduct, well then the United States is liable as well. And under the ordinary tort law, kicking in the wrong door would clearly trigger some sort of liability, and therefore this case should move forward. The Martins also argue that the DOJ's position would create some very dangerous consequences if it is allowed to move forward, and also if the 11th Circuit still rules in favor of the FBI and the government. If accepted, it would mean any law enforcement raid would be insulated from lawsuits simply by labeling mistakes as discretion. So they state that wrong house raids would be immune from accountability, and victims would have no legal remedy at all for even the most reckless conduct or the biggest mistakes made by the federal government. That would expand government immunity far beyond what Congress intended when they passed the FTCA and far beyond what the Supreme Court just allowed in this unanimous ruling. So what's the big picture with this case, and really where does this leave us? Well, now you have this 9-0 unanimous ruling by the Supreme Court narrowing government immunity. They sent this back down to the 11th Circuit for a fresh look at this case. The DOJ is still trying to avoid accountability, and they're saying that the 11th Circuit should still dismiss this case and really not take a fresh look at this like the Supreme Court indicated. And the 11th Circuit is now going to be forced to decide whether wrong house raids are protected policy decisions or if it's unlawful negligence. And all of this, again, is going to be reviewed by the 11th Circuit during those oral arguments on March 25th. This case is no longer just about one family. It's about whether federal agents can be held responsible when they invade the wrong home, or whether the government can always escape liability by calling something a mistake, but really just saying that that is discretion. So any mistake they make is really discretion, and therefore they have broad immunity. The Supreme Court made very clear that the lower court here needs to draw a very clear line on this issue and take a fresh look at this case. And now the 11th Circuit has set oral arguments to take place in this critical challenge on March 25th. So that's where things currently stand right now in this critical Supreme Court accountability case. After it was sent back down to the 11th Circuit, the DOJ continues to fight to preserve immunity. The Martins here, the family, continue to push back, and the 11th Circuit must now apply the Supreme Court ruling and decide whether this case goes to trial at all. But the DOJ, like I mentioned, is still doubling down in trying to repackage the same arguments that were already rejected by the Supreme Court. So that's where this is currently moving forward. That's what's happening in this critical case. As we get more information, as this develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.